We're in Springfield, Ohio, and the owner of John's Drive-Thru is closing up shop for the night. A man approaches from the back. The owner spots him on the security camera feed.
No! Get the hell! Emergency. Yeah, this is John's Drive-Thru, West Main Street. A guy just tried to rob me and I shot him. He ran out the back door.
Okay, is he injured?
I think I hit him.
With help from the store's security camera footage and a tip from a local hospital who treated a man for multiple gunshot wounds, police identified the perp as Ricky Hand, a known career criminal.
I did try to rob John's Drive-Thru. I got shot 3 times. I did the crime, I ain't gonna lie. I just wanted to let you know.
So, John, what'd you do with the pistol that you had when you were in there? Because, you know, it's my understanding when you run it in there, you started pulling out and the guy saw you.
Right, but I didn't even get it out.
You were going for it, though, right?
But I didn't even get it out. I didn't branch it. He shot me regardless.
Well, I think he's well aware that you've been robbing places at gunpoint or so.
I've never robbed anybody. That's the first one I've ever done.
Now, hang on a second. Now, you and I have been straight with each other every time we've met each other, okay?
Yeah.
I know there's more to it than that.
I pulled it out. Okay. Pulled the weapon out. But I don't think I got it all the way out.
Well, he saw you. That's why he shot you.
Hand is indicted on 30 charges connected to a string of business break-ins at gunpoint. He confesses to a series of armed robberies.
There have been probably a half a dozen or more robberies. Now, you're looking at John's. You're looking at this break-in to this beauty salon.
That's all I've done.
The beauty salon's a bonus because I didn't even know anything about that, and you told me that.
I'm going to prison for a long time.
Well, you know that.
Now Hand sits in a Clark County courtroom in Ohio, where a judge has just handed down his sentence.
Did you just give me 40 years? Sir?
Yes.
You just gave me 40 years. Well, guess what?
Sir, what's this?
Hand was clearly expecting a lesser sentence. But if we look again,
Did you just give me 40 years?
you'll see he came prepared for the worst.
You just gave me 40 years. Well, guess what?
Look closely. Hand reaches into his arm sling and pulls out some cloth that was hiding a small bottle filled with, ready for this? His own feces and urine.
You can't play Jesus and God! 40 is a death sentence, man!
Ricky Hand lands in even more trouble for the feces-flinging attack. In addition to his previous charges, he now faces charges of harassment with bodily fluids, obstructing justice, and retaliation. Next, we're in Detroit, Michigan, where 29-year-old Dominique Slaughter is scheduled to turn himself in and begin a previously ordered jail sentence. 3 years earlier, Slaughter was arrested and charged with possessing a stolen credit card and carrying a concealed weapon. He pled guilty and was sentenced to 1 year in jail and 18 months probation, plus restitution and fines. Despite failing to report to jail, Judge Kelly Ramsey allowed Slaughter to remain free on probation with a GPS tether while he worked to pay off his restitution and also resolve 6 outstanding warrants he had in other jurisdictions. Today, 14 months after sentencing, Slaughter's scheduled to surrender to the court and start serving his year in jail. But first, Slaughter's probation officer, Brittany Wisser, informs the judge that Slaughter has not exactly been complying with her probation orders.
Mr. Slaughter still has not paid anything towards his fees, costs, or restitution. He has not resolved the 6 pending warrants that he had. He now has an additional 4 warrants as well, which are for driving without a license and for narcotic possession. He failed to appear for sentencing. The tether reports will show that he has multiple shutdowns of his tether, meaning he has failed to charge that tether and it was shut down. There's a total of 11 shutdowns, and then there is a home zone violations as well. There's 21 of those violations. Those are saying that he's not in the home when he was required to be in the home.
But the judge seems more concerned with getting Slaughter to serve his long-delayed jail sentence.
I'm not going to deal with any of this today. This is a surrender date for Mr. Slaughter, and that's what's going to happen. If there is a violation of probation filed or a tether violation filed subsequent to this, then you'll receive notice and we'll hear it.
When the judge mentions his impending jail time, Slaughter becomes distraught, raising his hands and holding his head.
What's upsetting you, Mr. Slaughter? Sheriffs don't like you turning around. Stand still, face me. This is a surrender date. I'm sorry I asked for an update, Mr. Slaughter, if a fraction of what she said is true. No, this is a surrender date, Mr. Slaughter. A surrender date.
I didn't think that I'd get locked up because the work was in there, so I thought I was gonna get continued. That's why I even went to work today, Ms. Randy.
Objection to work release if work release is offered, Mr. Slaughter. If it is offered, it is not offered. It doesn't exist anymore. This was a plea, not a trial, a plea. I'm not relitigating where we are.
I get my direct deposit tomorrow. I just wanted to make sure that my wife and them were straight as it.
You knew that it was today. The direct deposit's gonna be there tomorrow.
I just wanted one day to take please.
Your wife, doesn't she have access to your bank account?
No, she don't. No, she don't. My wife got a spending problem, so I keep all my money to me. That's all I'm.
What are you gonna do for the next 11 months in the Wayne County Jail?
She's gonna have to figure it out.
Well, then she had to figure it out before today. Today's the surrender date, Mr. Slaughter.
Judge Ramsey's had enough and is ready to move on. But Slaughter continues to plead for more time.
Just till morning, Miss Randy. Just till morning, I still gotta tell her.
This is disingenuous, Mr. Slaughter. You can't ask me for any more time. I've been as generous gift. Mr. Slaughter, you see the 3 pages of people who need to see me today. Read those
Yes, I
pages.
need everything just tonight, Miss Ramsey. Please. I would turn myself in the morning. I would come straight down.
Come on now, Mr. Slaughter. Today is the day. How many pleases do you get out of me?
Just asking for a few hours, please. Just a few hours. Just to say bye to my family and everything.
That was last night. That was last night.
Miss Ramsey.
You're at the end of probation. You gotta serve this time.
Oh, I'm sick.
Go with my sheriff. Come on. Come on now. Breaking the law has its consequences.
Slaughter is now serving his year in jail. When released, he'll still need to complete 4 more months of probation.
Just give me time for all of it right now. I just need a little time. It's gonna help me look better anyway. So.
We're in Broward County, Florida, for the arraignment of 32-year-old Bradley Quimbley on a petty theft charge. 2 days earlier, Quimbley was arrested at a local department store for walking out with a television that wasn't paid for and threatening a store employee who tried to stop him. Today, he's appearing before Judge Jackie Powell.
Mr. Bradley Quimbley on page 11.
Yes, he's here, present, Judge.
So, Mr. Quimbley, you're before the court today for 1 count of petty theft, and the court does find probable cause. Does the parties wish to be heard as to bond?
My name's Mr. Quimbley.
I believe he wishes to resolve this case today.
Yes, I do, miss.
All right, State, do you have an offer for Mr. Quimbley?
State's offer would be 10 days. I would note the TV he stole was 1 penny under the grand theft amount.
Judge, and speaking of Mr. Quimbley, right now he is working. He works for a moving company. He doesn't want to risk losing that job. It costs him a lot to get that job, Judge.
I need it, miss. You know what I mean? I need my job. You know?
Mr. Quimbley, please stop talking and allow your attorney to speak, okay?
I'm going to ask the court to consider releasing Mr. Quimbley on time served.
I would note there's allegations that he threatened to physically harm the employees at work.
It's a simple case, and everyone agrees on a deal for 5 days in jail with 4 days credit for time served.
All right, Mr. Quimbley, please raise your right hand.
That is until someone checks Quimbley's other court records and informs Judge Powell.
All right, I've just been advised that Mr. Quimbley is on pretrial supervision. So, on what case?
On January 29th, it was 1 count of assault.
Judge Powell discovers that Quimbley's on release pending trial for another incident. 1 month earlier, while at a supermarket, Quimbley took 2 items from store shelves that he immediately then tried to return. The incident also included threats.
I think the court should be aware that that case also involves allegations of fraud at a where he again became irate and began to verbally threaten to cause physical harm to the employees.
These additional charges, along with his history of threats, make Judge Powell rethink Quimbley's plea deal. Perhaps sensing things slipping away, the defendant makes a last-ditch effort to settle both cases today.
Whoa, what is this? Just give me time for all of it right now. Just give me time for all that so I can just go ahead and just settle that. It don't matter if it's 10 days, 20 days, 30 days, 60 days. Just let me settle that. All of it, right now. So I don't have to be worrying about this and that.
All right.
I need a little time. You're going to help me look better anyway, so.
All right, well, we're gonna have Mr. Quimbley take a seat a little bit, and I will recall the case.
Yes, Judge. All right, pretty lady.
Quimbley gets away with calling the judge pretty lady, but when she recalls his case later that day, she's not giving him anything to joke about.
I'm revoking his pretrial, so counts 1, 2, 3, I'll impose a bond of $500, and I'll ROR him on 4. That's on the pretrial supervision, and then on the new charge, the bond is $100. I'll leave that in place.
Judge Powell decides to revoke his pretrial supervision and impose cash bonds totaling $1,600. Earlier today, Quimbley was flippantly asking for jail time.
Need a little time. You're going to help me look better anyway.
And now, unless he can come up with the bond money, that's exactly what he's getting. Quimbley's mic has been turned off, but he's clearly fired up. Quimbley lashes out, slamming his hands on the podium, then knocking it over. Because his microphone is switched off, the judge doesn't hear him swearing and threatening to kill her. But the sheriff's deputies wrestling with him hear it all. Quimbley racks up even more charges, this time felonies, resisting arrest and threatening a public servant. Judge Powell barely registers his outburst and moves on to her next case.
Is the podium up or down?
Because of his courtroom outburst and threats against Judge Powell, Quimbley's bond was raised from $1,600 to $6,000, and he remained in jail until his hearing 8 months later. There, he pled no contest to the felony charges and was given 364 days in jail and credit for time served. Months earlier, Quimbley also pled no contest to the charges related to both store incidents. He was sentenced to 3 months probation and ordered to attend a shoplifters program. He has since completed his sentence. Next, we're in district court in Ann Arbor, Michigan for a pretrial hearing. 26-year-old Cory Duncan is charged with second-degree retail fraud and second-degree conspiracy to commit retail fraud, both misdemeanors. 7.5 years earlier, a then 18-year-old Duncan was arrested on shoplifting charges at a grocery store and released pending trial. But just 4 days later, Duncan was arrested again on unrelated felony charges, unarmed robbery and 2 counts of assault with intent to rob and steal, unarmed. The shoplifting charges were put on hold while Duncan was convicted and then served over 6 years in prison for the felonies. Now Duncan's been out on parole for a year and is appearing before Judge Cedric Simpson for the original shoplifting charges. He's expecting to plead guilty as part of a deal in exchange for a sentence of time served.
First question I have for you is, do you wish to be represented by counsel?
Yes, sir.
In fact, Duncan's already met with public defender Chinaza Ikuri, and while the hearing has barely started, she needs a word with the judge.
Your Honor, if I may, I do apologize. I spoke with Mr. Duncan. If we could possibly approach for 2 minutes to discuss what we're looking for in this case.
All right. Bring me to a breakout room.
After a 6-minute conference, the judge and public defender are back, and Duncan is in for an unpleasant surprise.
Record should reflect there's a request for an adjournment of the pretrial. Will adjourn it to April 20th, 2022 at 9 a.m. So I will set the defendant's bond at a personal recognizance, $10,000 bond. Sir, as a condition of your release, there's to be no use of alcohol, recreational marijuana, or any illegal drug. Do you understand that?
I'm confused as to why, I thought I was supposed to get time served today.
Mr. Duncan, that's what we went to speak with the judge about. I'm going to give you a call here in a minute. There's another issue that you and I need to discuss, which will not allow us to take that plea that we talked about today.
An issue the court has not made public has blocked Duncan's plea agreement.
We can't do, I think, whatever, you have to assure me that it can be resolved on the 20th.
He doesn't have to assure you of anything.
Duncan's motivated to wrap up the case before he completes parole in the coming weeks, but his demanding attitude sets off the judge.
He doesn't have to assure you of anything.
All right, man.
No, I am not your man.
All right.
Never address me that way.
I apologize on his behalf, Your Honor. I do. We received the date for the adjournment, and I will be sure to speak with my client today.
Ikuri tries to smooth things over for Duncan by apologizing to the judge, but he's not helping himself by dropping off the call.
He needs to come back on because I'm giving him his bond conditions. He better be on, right now. He better turn that video back on.
Or what?
Or
what?
He's here, Mr. Duncan. Mr. Duncan, allow the judge to speak. Mr. Duncan, allow the judge to speak.
You want me to revoke it? I will. But you want to try to do it your way. We can do it your way. That must be the hard way.
I turned myself off the video camera to compose myself.
Okay, Mr. Duncan, I got you. It's okay. Your Honor, I apologize. We are ready to receive the bond conditions. Mr. Duncan, I will call you as soon as you hang up.
With Duncan's bond set and next hearing scheduled, Judge Simpson is ready to move on to his next case.
You want to play with me today? You know, I was having a good day. Till just then. So who wants to go next?
Next, we're in Miami, Florida for a bond hearing. 30-year-old Travis Green has been charged with petty theft and battery. Today, Green appears before Judge Mindy Glazer, hoping to be released.
Hi, Mr. Green. Good morning.
But Green has a lengthy criminal record dating back to 2011, including charges for grand theft and burglary.
Sir, you were arrested for petty theft and battery. I will appoint the public defender's office for you.
Before discussing bond, the judge has a question about the charge.
This is at the Family Dollar store.
Yes, ma'am.
He said he went into the store, picked up multiple items, and then walked out of the store not paying, came back with a pliers tool in his hand, screaming and yelling in the store. So if he's using force, isn't this a strong arm robbery?
The public defender, Renee Gordon, disagrees.
Judge, I don't think it is, given that the defendant hit a product out of his hand, causing the product to become loose. I'm not sure that would even qualify for a battery, as it's not clear that the man was actually touched.
Then he came back in the store a few minutes later with a pliers tool in his hand, screaming and yelling.
He had him in his hand, but he didn't say he did anything with the pliers. Didn't even say he made any threats. So at this point, I do think what the court has is definitely a petty theft. I'm not sure about the battery.
I'm never going to that Family Dollar again, ever in life.
Judge Glazer checks in with the prosecutor, who appears off camera.
I know what the state's seeking. You want a bond?
Yes. There's nothing specifically said that he touched the person. Said he touched the product, and the product
was in the person's hand. That is a battery.
When the two attorneys are done arguing, the judge makes her decision.
So count one, there's probable cause for petty theft, $500. Count two, battery is $1,500. Have a good day.
But the public defender isn't quite ready to give up.
Judge, would you consider pretrial services if he has a good address and a phone number?
Not on these priors.
Judge, the priors are somewhat dated.
State would object on the fourth.
State's objecting. Well, I'm concerned because he hit the guy. Really should be a strong arm, right?
I didn't touch the guy at all, Your Honor. I promise you.
Oh, no, not the guy. The package out of his hands.
Does not say that he came in and hit anyone.
Your Honor, what concerns the state is that after leaving, he came back with pliers in his hand, screaming and yelling at the people in the Family Dollar store, not allowing them to do their jobs.
Pliers to do anything. He may have just had pliers with him. It doesn't, sir. It's okay.
Judge Glazer ultimately sticks with her ruling.
I'm not giving free trial. It's a bond. Let it post a bond. It's $2,000. 500 count one, 1,500 count two. Have a good day.
You nasty.
No, you nasty. Hold on.
Miss Courtney, let it go. Not worth doing a contempt. Just let it go.
On his way out of the courtroom, Green smashed a glass and was charged with criminal mischief. The next day, he was given an additional bond of $1,000. Green was eventually released after posting all of his bonds, and his cases are pending.